So now that you understand the basic philosophical underpinnings and scope of the RESPA statute, let's talk about what the scope and shape of RESPA looks like to you in the actual real estate world in which you practice. We're going to do that in Module 4. First of all, RESPA only applies to settlement service providers. We talked about this earlier when we said the issue as to what I could and couldn't give my clients as a result of doing business with me is outside the scope of the federal statute and depends entirely upon the state laws and the jurisdiction in which you are located. So the question we have to answer is, who is a settlement service provider? You know, certainly the real estate agents are settlement service providers, mortgage lenders, bankers, title companies, appraisal companies, home warranty companies. Not as a hard and fast rule, but more as a guideline. HUD has generally deciphered this question by simply stating that if they provided services to a real estate client that were necessary to close and complete the transaction, then they fall under the category of a settlement service provider. These are the people that the RESPA statute was meant to regulate. And the primary prohibition in Section 8 of RESPA against the interactions between these settlement service providers, as we said earlier, doesn't have to do with the ability to refer business. In fact, I think both HUD and the Consumer Financial Protection Bureau would both agree that they want us in the business of making referrals to other settlement service providers. The prohibition of Section 8 is against giving things of value to other settlement service providers for the referral of business. So, what's a thing of value? Well, it can be just about anything. Certainly we would all recognize cold hard cash as being a thing of value, but so are free trips, vacations, lavish dinners, and those types of items which you often see exchanged for the referral of real estate business. So let's deal with it in terms of practical, real-world questions. Because I don't know about you, but at least for me, from an educational standpoint, things like complex federal statutes and rules take on one meaning when we're talking about them out of context in terms of their cold, blank provisions, and an entirely different thing when we take those federal laws and try to apply them to actual real-world situations. So here's a safe boating test for you, and a real-world practical question. Can a mortgage lender agree to pay for an agent's open house signs? You guessed it. The answer would be no. Clearly, that would be providing something of value, the cost of the signs, in exchange for the referral or the expectation even, HUD would say, for the referral of business. They can't pay for your open house signs. They can't pay for your business cards. HUD looks at that as not being much different from them handing you cash in that regard. How about this question? Can a title or escrow company then bring flyers and cookies to the agent's open house, promoting their title company and talking about the services that they render? The answer to this question is yes. They certainly could provide that, because they're not giving anything of benefit or value to the real estate professional holding the open house. They're giving something of value to the clients. And, more importantly, they're not promoting the agent, they're promoting themselves. You know, one of the harsh realities of teaching RESPA over the years, and possibly of some of the classes or courses that you may have taken on the subject, is that all too often we tend to scare people into being too restrictive in their business practices, and we throw out, well, the baby with the bathwater. So I have heard individuals say, no, we no longer let people come as title companies or as mortgage lenders and speak at our real estate office, at our luncheons, or bring in lunch and have a lunch and learn, because it might be construed to be a violation of RESPA. HUD has never held that someone sharing information with another settlement service provider and helping them to understand the way they worked or promoting themselves in the normal course of ordinary business activity was ever a violation of RESPA. Can a realtor association offer free classes to its members? The answer is yes. So we're going to spend a whole lot of time talking about classes and the providing of them. It's a common and typical question we hear all the time surrounding RESPA. But the association would be exempt from this statute because they are not a, you guessed it, settlement service provider. They're an outside entity providing free education to their members, and if they choose to do that as part of the services and benefits they offer, well then good for them. The issue with RESPA arises, for example, when a title company or when a mortgage lender would decide to hold a class that was free for real estate agents. Is that, in the opinion of the people who work at HUD and in the regulatory bodies, a violation of RESPA? They have typically said that it becomes a thing of value when we offer course credit. Course credit, something which is required by the real estate licensee, and therefore the providing of it free defrays an ordinary business cost that the licensee would have. So HUD has typically said that when a settlement service provider is providing free education to which credit hours are attached, that is a thing of value, and therefore the settlement service providers must charge a reasonable or market-related fee in regard to the providing of such education. It wouldn't apply if there was no credit hours attached. For example, if the mortgage lender wanted to come to your office and spend an hour talking about changes in FHA rules or regulations, or if the title company wanted to come to walk the agents through the new good faith estimate or the new HUD and talk about the changes that have occurred in the form over the last couple of years. Those are typical educational opportunities where the only thing given of value to the licensee is the education. And that in and of itself, HUD has determined is not a thing of value. It's the issuance of the certificate that draws the distinction. The next question, can an agent give a client $1,000 to pay their title or escrow fees? You know, the answer to this in many states is yes, and you may have been the victim of this. Sometimes we call them commissionectomies. When a client gets to the end of a transaction and doesn't have enough money to close, and the real estate agents or other settlement service providers lower their fees. The two reasons that it's not a violation of RESPA. First of all, it is not something of value being given to another settlement service provider. It's an item of value that is being given to the client. And if it's good for the client, then typically it's good with RESPA. And the other reason that it's not a violation is because we said much earlier that what we give and provide to our clients as a result of doing business to us is up to our state regulations and statutes to sort out. Can a home warranty company give a free warranty to the agent for every 5 ordered? Well, given HUD's most recent rulings on this, the answer would be no. This is giving the agent something of value in exchange for the referral of that business, and it would be a violation. Are there ways, creatively, to craft a relationship in today's world with a home warranty company and me as an agent that would not violate RESPA? And the answer to that is certainly yes. What if the home warranty company were to promise to give every client of Len Elders a $50 or $100 discount off the home warranty? Then again, we've transferred that into a benefit that is derived by the client and not something being exchanged by the settlement service providers. So that type of application would be okay. All of those items of value questions and the analysis we provided beforehand relate to Section 8 and Title 8 of RESPA. Section 9 of RESPA has to do with the forced use of certain settlement service providers. Hey, in our maritime theme that we've been following through since the beginning of the class, I guess what we'd say is you can't make your clients walk the plank. Section 9 of RESPA says that I cannot require you as my client to use a specific settlement service provider. And for further understanding of the issue, we have to look at this definition of required use as found in the federal statute. The federal statute says that required use means a situation in which a person's access to some distinct service, property, discount, rebate, or other economic incentive, or the person's ability to avoid economic disincentive or penalty, is contingent upon them using or failing to use a referred provider of settlement services. And you may have seen lots of evidence of this throughout the real estate industry, particularly in the 1980s and the 1990s. There were many builder entities which said, for example, if you buy a new home from us as a builder and you use our real estate company as the listing agent in dual agency with you as the buyer purchasing a new home, then you must use our mortgage company or you must use our title company. That is prohibited by RESPA. It's interesting that many of the builders tried to craftily wind their way around this statute by saying, well, we're not requiring them to use it. We're just taking away the free options or other items that you would have gotten in the real estate transaction had you used our builder. If you take a look at the language of this federal statute, I think you'll agree with myself and with the regulators at HUD that those kind of arrangements as well are violations of the required use provision. I want to be very clear about what we're talking about here. It would be, for example, a violation, a clear violation of Section 9 and required use for me to say, you must use our mortgage company or you don't get these benefits. By the same token, if I change the nature of the relationship and I simply say, I work with a mortgage lender who, if you use them and you're my client, they will not charge you for a application fee, a credit report fee, they'll even pay for the appraisal, and we craft that benefit in that fashion, then it's not something I am holding or restricting. It's a benefit that settlement service provider is giving you because you are my client, and it's a benefit to the client, not something that I am getting back as the settlement service provider. So I hope that clarifies some of the questions and concerns that you may have had about required use. So here's the question from the real world. Can a builder require a buyer to use a specific mortgage lender? We've already said the answer to this question is no. And how about this question? Can a builder offer options only if the buyer uses their lender? The definition of required use would also make this a violation. Could a home inspector give a $10 Starbucks card to an agent for every referral? You know, does that sound to you like the giving of something of value in exchange for the referral of business? I think you have to agree that this would not be permissible and that it is indeed a violation of the federal statute. And notice that there is no limitation on the dollar amount. HUD doesn't care whether it's $10, $5, $50, or $500. Can we change the nature of the incentive? Could the home inspector give the Starbucks card to the client if the client hired them for the home inspection? That's an entirely different issue. It's between the client and the home inspector, not the relationship between the settlement service providers, and therefore falls outside the purview of the federal statute. Can an REO bank seller require that the buyer use a specific title company? We've seen a lot of this in recent markets where the bank or the lending institution is the REO owner of a foreclosed property, now in resale requires the buyer to use a specific title company or mortgage lender. That would be typically a violation. But I have to give you the patented lawyer answer of maybe. And here's why. Because on further clarification with HUD, what HUD has said is this: there may be legitimate and fundamental reasons why a specific title company may be required by any particular seller. And a seller certainly can request or even insist, HUD would say, that the buyer use a particular title company. The additional impact being that if the seller has required that, then the buyer cannot be held responsible for any of the closing or the escrow costs. Those would be the responsibility of the seller. Because if you think about it, the reason the sellers would want this to happen is because they're getting a discount, not simply because the costs can then be heaped upon the buyer or multiplied ad infinitum. So if they're going to do this, the seller has to pay all of the closing and title costs with the exception of the buyer's ALTA policy. Because regardless of where I close my transaction and who the particular title or escrow holder may be, I can always select a separate company for the purchasing of my ALTA policy. So that's HUD's decision and clarification of the issue. Can an agent jointly advertise with a mortgage officer and recommend clients to them? The answer to this is yes. HUD allows and encourages joint advertising. They would hope you take out joint advertisements between real estate providers, mortgage lenders, title representatives. We could do that in printed form. We could do that on the internet. We could do that in terms of trade shows. HUD would simply require that we share the pro rata costs of that advertising. It's easiest to see if we look at it in terms of a one-page magazine ad. If I take the top half of the page as a real estate professional, my home inspector or mortgage lender takes the bottom half of the page, then we would have to 50-50 split the costs of that advertising. So joint advertising is permitted so long as it's done on a pro rata basis. Speaking of the relationships of settlement service providers, Section 9 of RESPA has some very specific provisions for the instance where we are dealing with affiliated business arrangements. You'll see them abbreviated as AFBAs and ABAs. To HUD, they're the same kind of entity, and it's the acronym for an affiliated business arrangement. HUD allows owners of companies to have ownership in more than one settlement service provider. It's perfectly legal under federal law for me to be the owner of a mortgage company, the owner of a real estate company, and the owner of a title company. And I am perfectly free to refer business to the other affiliated entities in which I also have an ownership interest, so long as I meet some additional requirements under the federal statutes. So we have to start with what is an affiliated business arrangement. Well, it applies to co-ownership in more than one settlement service provider, and all I have to own is at least 1%. That settlement service provider must perform legitimate work for the client, and there is some additional disclosure required. The mandatory AFBA or ABA disclosures must disclose the nature of the relationship, can't force the client to use that entity, and have to disclose the fees that the client is going to be charged. So, for example, if I am Lens Realty and I am also the co-owner of Lens Mortgage Lending, I can ask my real estate buyers all day long to please use an affiliated mortgage lender that I also own. And when I make that referral, I have to tell them that I have an ownership interest in the company. I have to give them a disclosure that says they are not required to use that lender, and I have to disclose them the potential fees that lending entity would charge. There is a form for an ABA AFBA disclosure on HUD's website. If you're not using one, please go to the HUD site. You'll find the link attached to this course, and also the link to the mandatory AFBA disclosure, which is required under federal law when we have affiliated business arrangements. So how about some more real-world questions? Can an appraiser and a real estate company share a booth at a trade show? Well, the answer to that would be yes. They just must share the pro rata costs because RESPA allows for joint advertising. Can a real estate brokerage own a title company and a mortgage lender and refer clients to them? We said yes, but if there is commonality of ownership, then I must also meet those additional ABA disclosures. Can a real estate company arrange a home inspection that costs $250 and then mark it up and charge the client $350? The answer to that is no. And it's no for a couple of reasons under RESPA. Number one, this does involve the splitting of fees between settlement service providers. And the $100 difference that I put in my pocket, there was no valuable service provided by me as the real estate agent for that. So be aware of this cost and fee splitting rule. Can a real estate company provide free office space to an insurance agent? Well, certainly the real estate company and the insurance agent are both settlement service providers. And if they are providing free space, then that very well might be construed by HUD to be a thing of value given in exchange for the referral of business. I would have to charge them the reasonable fair market value of that space in order not to be in violation. Could a real estate company with a title license receive fees for the referral of their title work? Well, I certainly can own a real estate company and a title company, and I would have to make the ABA disclosures. But I can't charge fees from my company unless I'm actually performing some of the title work. In other words, I can't just set it up as a referral entity. So there are some real-world applications having to do with Section 8 and Section 9 of RESPA, the providing of things of value and the existence of affiliated business arrangements, two of the most common areas in which we get into trouble as real estate professionals and as other settlement service providers. So I hope these ideas and the understanding of these concepts in more depth helps you have safe sailing.